welcome everybody to tonight's webinar, Preemption, County Authority, and CO2 Pipeline Ordinances in South Dakota. This webinar is being put on by a couple different folks. We've got some South Dakota landowners who have been helping lead efforts for county action in the pipeline process. Also, Bold, Nebraska is providing some of the background web support. And also Paul Blackburn, our main speaker, is an attorney with Bold. And then my name is Chase, and I work with Dakota Rural Action as a community organizer who has been working with landowners directly impacted by the carbon pipelines for almost a year and a half now. So we are very glad that you all are here, and we're excited for this important conversation that we're going to have this evening. So a few housekeeping pieces before we get into it. The first is that as this webinar goes forward, you are invited to put questions into the chat. You can also submit questions to the Q&A button that you should have on the bottom of your Zoom screen. And the Q&A button will allow us as presenters to see them as they come up and mark them as we get to them. So if you have something you want to make sure we get to, go ahead and put it in the Q&A, and it will stay at the top until we answer it, and might get lost in the chat. So be sure to put important questions in there. Tonight's webinar will be recorded and made available to folks who weren't able to be here live tonight. I know there was some activity up in the Brown and Spink County area, and there were a lot of people who were not able to make it tonight due to that conflict. So know that this will be made available afterwards in case that you missed something or you want to go back and hear it, or if you have a local official or a colleague who you want to share this information with. And lastly, I've done a little bit of introduction here, but I have shared some about myself. I also want to give an overview of the time that we'll spend together here. So just a minute, I'm going to hand it over to Tony Ventura, who is a landowner in South Dakota, who has been really active in the southeastern corner of the state on this issue and helping to get other landowners more aware of what they can do to be involved, and also very involved with encouraging counties commissions to take action. And then after Tony shares a little bit, we're going to hand it over to attorney Paul Blackburn. And Paul has worked for a long time in pipeline related law, and so has become somewhat of an expert. Probably isn't super happy that he's had to become an expert, but is very knowledgeable and an excellent resource who has already helped tremendously with landowners, but particularly helping local officials understand the power and jurisdiction that they have, which previous to a big interstate project like this was not probably covered in the How to Be a County Commissioner 101 training. So he has been a really helpful asset, done a lot of research and writing and speaking about the topics we'll cover tonight, and is going to stick around after his presentation to answer any of the questions that arise. So without further ado, I'm going to pass it over to Tony Ventura to make a few remarks.
Hi, and welcome you all. My name is Tony Ventura. I've been fighting the CDP for quite a while with help from Paul and Chase and everybody else. But I guess I just want to explain how I do things, and hopefully you can use it as a useful tool to work in your area. The first thing is to read and understand the comprehensive plan in detail. A lot of times I go to elected officials, even the mayors, and I say, you know, it says if this affects the agricultural zone, you're immediately supposed to have hearings. And they say, oh, I've never heard of that. And you literally have to bring them the page and educate them. And that also gives them some reasoning for maybe starting these discussions with other people. And so I think that's very important. The other thing is go talk to everybody, every local official, all the way from the commissioners to the mayor, to the planning and zoning emergency management director down to your township boards, and try to involve them as much in these discussions as possible and educate as you go. One thing I've tried to become is an expert in the county. And so instead of them calling the planning and zoning director, they call me and ask me questions. And I think that's very important, that you become an expert, that you can answer the questions. And if you can't answer the question, you try to find the answer for them. And so that's part of the process is a lot of times the commissioners and the planning and zoning board and the mayor are so busy doing everything else, they just don't have time to understand this. And so you have to make it kind of a due diligence on your behalf. But no matter what it is, if you don't know the answer, don't tell them you know the answer. And second of all, say, just like with Paul, sometimes I have to reach out to a smarter person in the room or find a smarter person to give you that answer, because that's how you build a good, honest base behind you.
And Tony has definitely been a force to be reckoned with down in Minnehaha and Lincoln County area. So I'm super thrilled and glad to learn by his example. For those of you who are just joining on, we're about to hand over to Paul Blackburn, Attorney Paul Blackburn, to discuss preemption, county authority, and the CO2 pipeline ordinances. So if you're on this call, it's likely that you have a sense of the big picture of what's going on in South Dakota. But I'm going to lay a few pieces out there that were the groundwork for why we thought this topic deserved an hour of our time and an hour of your time on your Tuesday evening. When the CO2 pipeline projects came into the state, there was a lot of concern, a lot of running around, neighbors talking to neighbors. Who is this going to be decided by? What is this project? And very quickly was a recognition there's going to be a PUC permitting process. There was quick recognition that some of the eminent domain laws maybe needed to be tightened up with legislative efforts. But there was also very quickly, as folks began to dig into who has the ability to regulate these projects, the understanding that the counties would be a critical piece in making sure that these projects were not allowed to go through without a high priority put on the interests of local communities, future economic development of the region. And so the question of preemption, county authority, what can the county do, became kind of the flash fire in the pan, where a lot of controversy has, and really misunderstanding, misinformation even, has come. And so we've had many counties throughout, not even just South Dakota, but the region, where landowners have been going to their local officials, their commissioners, and asking them to consider putting in ordinances, which would put in basic planning and zoning ordinances and I'm losing my word, regulation for these new projects, because we haven't had carbon dioxide pipeline in the state yet. This quickly was countered by lawyers and representatives of the pipeline companies themselves, who began coming to counties and saying, you can't do anything. It's all federally preempted. And there was a lot of he said, she said, who is telling the truth, state's attorneys trying to dig into this issue. And it certainly is nuanced, but it's our belief that there is a lot of misinformation out there about what counties actually have the power to do, and that it's in the interest of the companies to keep it ambiguous about the power that counties do have, so that they have less oversight in their project, which gives them less hoops to jump through, as it were. So tonight, I'm going to pass it over to Paul Blackburn, and he is going to share some really good information on the question of what can counties do, what can they not do, and look at it through the lens of some of the CO2 pipeline ordinances that landowners have proposed in the state. So I will pass it over to Paul, and as Paul presents, feel free to write your questions in the Q&A again, and then at the end of his presentation, we will have that Q&A session. So Paul, go ahead, take it away.
Hey, thanks, Chase. Yeah, so basically, the pipeline companies want you to surrender before you even try to fight. One of the things that everybody does in strategy and conflicts is to try to get people to give up before they even begin to fight. And one of the ways they do that is by convincing folks, or trying to convince folks that they're not legally allowed to do anything. And the pipeline companies will say and make arguments that are very poor, very weak, or even directly misleading, in order to get people just to give up ahead of time. In this case, with all these CO2 pipelines, the profits that are being granted by the federal government is so absolutely obscene that the pipeline companies have lots of money for lawyers and PR folks and consultants to come in and say all kinds of things, because they want you to give up. They want you to just not try. And what I'm here to do is to talk through some of these federal preemption issues with you, to talk about it with you. And we're going to have Q&As, a lot of questions that I'm sure you'll ask. But just be clear that these federal preemption issues are somewhat complex, and I could probably do an hour presentation on each of the sub issues alone. So I'm gonna drop through a lot of different issues here. To do a presentation to walk through it that way, and so yeah, we'll get into this. So let me just share my screen here. Okay, Chase, can you see that okay?
Yes.
Okay. So let's work into this. And I'm going to talk mostly about federal preemption here. The state preemption issues are a little bit different, but we're going to focus on federal preemption. So what legal authority do counties have to regulate carbon dioxide pipelines? And just to start off here, carbon dioxide pipelines are regulated similarly to hazardous liquid pipelines. They're not the same as natural gas pipelines. Interstate natural gas pipelines are regulated by the Federal Regulatory Commission. This is under the Natural Gas Act, and it's separate. So we're going to talk about specifically regulation of carbon dioxide pipelines in this presentation, not all types of pipelines. So what is preemption? We hear this word be thrown around a lot, and most non-lawyers are generally not going to be familiar with what it means. So I don't know if you can see that. Let me see if I can get this out of here. Okay. So first, let's talk about the 10th Amendment to the Constitution. And it says the powers not delegated to the United States by the Constitution or prohibited by it to the states are reserved to the states respectively or to the people. And my translation here is states and local governments may regulate anything the feds don't. So basically the way our government, our national government works, or the relationship between our national, state, and local government works, is that if Congress hasn't, or the Constitution hasn't regulated some area of law, or says the feds can't regulate in those areas of law, then the area of law remains to be regulated by the states or local governments. So that's one of the constitutional provisions that are relevant here. The other one is the Supremacy Clause. And it says the Constitution and laws of the United States are the supreme law of the land, and anything in the Constitution or laws of state contrary notwithstanding. So what does that mean? It means if the feds and states and local governments both regulate an activity, federal law trumps state and local laws. So Supremacy Clause says what it sounds like. It says if the federal government is regulating some area of law, then that it gets to, then its laws is supreme. So again, so you combine these, and it's the answer here is, well, federal law is supreme, but if the U.S. Constitution or federal statute passed by Congress does not regulate something, then the power to regulate remains with the states. So the question that comes down to is what, with regard to pipelines, is regulated by the federal government, and what has Congress said that the federal government either can't regulate or they just simply don't regulate? because it's not as simple as the pipeline company likes to say, that it's all, one big single ask to all this. It's much more nuanced than that. But anyway, so under preemption, if a state or local law conflicts with federal law, the state or local law has no legal effect. It's avoided. So you don't want to write an ordinance that is conflicting with federal law, because it would have no legal effect and it'd be a waste of time. But there's a hierarchy of law here, and so federal law may trump state law, and state law may trump county and municipal law, and county and South Dakota County law may trump township law. But there are gray areas here, because in some areas of law, the federal and state government share power, and local government share power. For example, law enforcement. We don't, like some countries have a national police force, and every police officer is employed by their federal or national government. In the United States, we've got the FBI at the federal level and other law enforcement agencies, but then there are the state highway patrol and state enforcement agencies. But there's also county sheriffs and local police departments, and so even though the federal government does regulate certain aspects of criminal law and law enforcement, it doesn't regulate them all. There's definitely a shared power in this area, and the truth is that with pipelines, there's also shared power. And we can send you a letter by PHMSA, the Pipeline Hazardous Safety Administration, who enforces the Federal Pipeline Safety Act, talking about that state and local governments have an important roles in pipeline safety regulation, and some 2014, and the federal agencies just said flat out, yep, state and local governments have a role in pipeline safety. But the extent of preemption depends on the legislature's intent. So if we're not certain about what's preempted or not, the touchstone here for lawyers is to look at what the legislature, U.S. Congress, said in terms of preemption. So let's talk about the Pipeline Safety Act briefly, because this is really where they come in and say, oh, it's all regulated by federal law and you can't do anything. And the federal law that they claim preempts almost everything that the states could do, they say, is the Federal Pipeline Safety Act. So let's get into this. The Federal Pipeline Safety Act imposes quote unquote safety standards on owners and operators of pipelines. Safety standards is defined by 49 USC 60102A2. And I just want to point out that there's a basic rule in law that a statute trumps a regulation. So this citation here is to 49 United States Code USC section 60102A2. And that means the US Code is a statute. That means it's the supreme law of the land. A regulation, and I'll show some citations to regulations later, is subservient to the statutes. So a regulation cannot be interpreted to violate a statute. So the company will come in and talk about what regulations say, but they do it outside the context of saying what the statute says. And the statute is what really defines the law. The regulation has to comply with the statute. And I'll talk about that later. But anyway, so safety standards are defined by this federal statute to apply to, one, pipeline transportation and pipeline facilities. These are both defined terms. They have normal language definitions, but the statute expressly defines the terms transportation and pipeline facility. And it is important to understand what those specific definitions are, because the statute is crafted quite carefully by Congress to have a clearly defined scope of the term safety standards. These safety standards can apply only to the owners and operators of pipeline facilities. They can apply to other entities that don't own pipeline facilities. So for example, your local government is not an owner or operator of a pipeline. So PHMSA can't come in and do safety standards that force your local government to improve pipeline safety. The Pipeline Safety Act is very clear. It applies only to owners and operators of pipeline facilities. This is the safety standards. And it says and the safety standards may apply to the design, installation, inspection, emergency plans, procedures, testing, construction, extension, operation, replacement, and maintenance of pipeline facilities. That may sound like an exhaustive list, but there are a number of items that are not included in it that are dealt with elsewhere. And so, but generally speaking, what a county cannot do is regulate a owner or operator of a pipeline facility. They can't tell an owner of pipeline or operator pipeline facility how to design, install, inspect, and do the emergency plans for, or operate or replace, all those things. They can't tell a pipeline company what to do with any of that in any of that area. And I think the easiest way to think of these federal safety standards is that they're like a building code for pipelines. So a number of you are probably familiar with it. There's the zoning code and there's the building code. The zoning code essentially says where something can be built and if something should be built in that location. And a building code says how it's built. So you could have, for example, a house that you want to build, and it could be built in different parts of town. And the local government could say whether your house can be built in a particular location. But it can be built in the edge of town, or it can be built in the middle of town, but the building code is going to be able to apply to it wherever you choose to build it. The same plumbing standards apply, the same electrical standards apply, the same, fire code standards apply, all those kinds of things apply, regardless of where it's built. And the same is true for pipelines. Wherever a pipeline a route is selected, that the Federal Pipeline Safety Act can apply to whatever pipeline route is selected for whatever reasons. The federal regulations are location neutral. You can pick any location you want, and the Pipeline Safety Act will apply fully to that location. And you can pick it for any reasons you want, and it'll still apply to that location. We'll talk about that with regard to route. But anyway, so just think about the Federal Pipeline Safety Act as the building code for pipelines. And what you can't do is tell them how to build, maintain, or operate, or design their pipelines, or do the emergency plans for their pipelines. So let's do the next slide here. And so the reason why the Pipeline Safety Act preempts local laws, that it has what's called an express preemption clause, and this is it. The state authority may not adopt or continue enforce safety standards for interstate pipeline facilities or interstate pipeline transportation. So it just says flat out that state authorities, meaning state or local governments, cannot adopt, cannot enact a safety standard or enforce that standard. But again, it's tied, notice this language is tied specifically to the term safety standards. Now, one of the things the industry says all the time is that anything related to pipeline safety is preempted. That's not what the law says. The law says expressly that what's preempted is the adoption or enforcement of safety standards. And that's why we have to go back to 60102A. Whoops, I'm going the wrong direction here. The 60102A safety standard definition is really critical, because that statute says, the preemption statute says that only enforcement or adoption of safety standards are preempted. This is very specific language, and Congress did that for a lot of very important reasons. Here we are. Excuse me, my mouse is getting a little sensitive here. So then there's the pipeline regulations, and again, here's the citation to the hazardous liquid pipeline regulations that they apply to hazardous liquids and carbon dioxide pipelines that are supercritical carbon dioxide pipelines. It's 49 Code of Federal Regulations, CFR Part 195, and then the sections we call 195.210 and things like that. Again, these are regulations, and they have to be read in accordance with the United States Code. They can't be read so as to violate the United States Code. And also, PHMSA cannot extend federal jurisdictions or power beyond those expressly granted to it by Congress. So PHMSA can't say, gee, it would be nice to regulate the emergency response plans for local governments because it would improve pipeline safety. So we're just going to do that. Well, PHMSA can't do that because, again, they have authority over safety standards related to pipelines, but only over, that means only over owners or operators of pipelines. So PHMSA can't extend their jurisdiction to everything related to safety in pipelines. It's limited by the express language of the statute. So does the PSA preempt state or local routing of CO2 pipelines? The answer here is very clearly no. And that's because the Pipeline Safety Act itself, again, 49 USC, United States Code 60104E, says this chapter does not authorize the Secretary of Transportation to prescribe the location or routing of the pipeline facility. So that means that the Pipeline Safety Act does not grant PHMSA the power to say where a pipeline should go, either its location or its route. You know, it has zero power to do that. And this is what Congress expressly says in the Pipeline Safety Act itself. This is why state and local governments may regulate pipeline routes. And there's no argument about this, at least there shouldn't be, because many states, including Illinois, Iowa, Minnesota, North Dakota, and a bunch of other states around the country regulate pipeline route, and they've regulated it for years. And that's because this statute says that the PHMSA and the federal government cannot regulate the routes of a pipeline under the Pipeline Safety Act. So for hazardous liquid and CO2 pipelines, there's just no doubt that state and local governments can route pipelines. Now, South Dakota law is unusual in that it has a permitting process, but it prohibits the South Dakota Public Utilities Commission from routing pipelines. And that means that the state of South Dakota has no authority to choose the route of a pipeline. It can't tell, the PUC in its permitting process can't tell a pipeline to take a different route. Just not allowed. And therefore, since, under the 10th Amendment and the way state law works, since both the feds and the South Dakota Public Utility Commission are prohibited by law from determining the route of a pipeline, in South Dakota, the authority to determine route remains to the counties. It's just like, these pipeline facilities are just other kinds of facilities. They're another structure or building, and they are subject to county zoning ordinances. And I don't have the citation right here, but South Dakota law is very clear that it says expressly that county zoning ordinances will apply unless they're found to be unreasonably restricted by the South Dakota Public Utility Commission. So there's just no doubt that South Dakota counties have the authority to route pipelines. But then the question is, that always comes up from the industry, is they always say, sure, state and local governments can route pipelines, but they can't consider safety when they're making their decision, because that's safety related. Well, first off, as I said, Pipeline Safety Act doesn't say that everything that's safety related is preempted. There are some federal court cases that are overly broad and quite old, let's say, have those words, but other federal court cases are much narrower and I think more precise in their understanding of the act. But I've been arguing this against the industry for a long time, starting with Keystone XL back in like 2010, and they bring in their high-powered lawyers, and they convince everybody that you can't consider safety and routing, and yet, and since then, there are these three cases, and I'm going to go through these in a bit of detail. These three cases have come out. There are three cases that consider whether a local government can consider routing and safety when they're routing a pipeline. And they're the Washington Gaslight case in Maryland, the South Portland case out of Maine, and the Bad River Band decision out of Wisconsin. All three of these held, they all considered this exact precise factor, this exact issue, and they said that consideration of safety as a factor in a location decision is not a safety standard. There are no cases on the other side. The pipeline industry can't cite any other cases that looked at specifically, the authority, the scope of authority of a state or local government to route a pipeline and consider whether they can, and evaluate whether they, considered safety and whether that was allowed by law or not. All three of them are on our side. All three of these cases are against the industry. And there are no other cases. And that's because when you get right down to it, the Congress basically said, look, we're not going to route these hazardous liquid and CO2 pipelines. We're going to leave that up to the state and local governments. And you know what? We're not going to tie their hands on what factors they can consider. There's nothing in the Pipeline Safety Act that says, well, you can route pipelines for any reason you want, but you can't consider safety. It doesn't say that in the Pipeline Safety Act expressly anywhere. It just says that PHMSA, doesn't have any authority to route pipelines. And so since there's no restrictions on what local governments can consider, they can certainly consider safety. And the other thing that they said is that the field of pipeline routing or facility siting is entirely separate from the field of pipeline safety. And if you think about it, the Pipeline Safety Act is about keeping oil or hazardous liquids or CO2 inside a pipeline and stopping spills. That's what the Pipeline Safety Act is all about, is preventing spills, ruptures of pipelines. Well, when a local government or a state government is deciding where to route a pipeline, that decision precedes any operation of the pipeline. It isn't moving any, it's just conceptual at that point. During a state or local permitting process, it's even possible for pipelines to be rejected outright, in which case, if they're never built, the federal safety standards never apply to them. But even if they're built, eventually built, the decision about where they're built doesn't make any difference in the application of how the Pipeline Safety Act safety standards apply. Like I said, it's like if you build a house in the edge of town or in the middle of town, the same building code applies. You can pick a pipeline route, to go right by hospitals and nursing homes and schools, and or you could pick one that goes through a much safer area. And either route you pick, the Pipeline Safety Act can apply fully to it. And you could pick one route based on purely economic reasons. So you could pick the route based purely on safety reasons. It doesn't make any difference whatsoever. What the choice was based on. Once a route is picked, then the Pipeline Safety Act applies, and then they can design the pipeline fully, and then they can build the pipeline and operate and maintain and do all those other things. But the decision on whether a pipeline should be built and its route precedes all those other steps in that long list of things the Pipeline Safety Act regulates. So route selection is a separate field of regulation distinct from pipeline routing, and the federal courts have been clear about that. So again, safety, state and local governments can consider safety, and that's what the federal courts have said. If they consider safety in route and in determining a route, it's not going to be a safety standard. So let's talk about these decisions briefly. I'll try to go through them quickly, and I have these in case you want to look at the presentation. But Washington Gaslight v. Prince George's County Council, out of Maryland in 2013. And basically, the Prince George's County government rejected an application for an LNG tank. Now, this LNG tank was regulated by Pipeline Safety Act, and so this was a Pipeline Safety Act case. And the county, it's a little bit ambiguous in the federal court, that's appeals court decision. But if you look at under the lower courts, the district courts, it's pretty clear the county was concerned about safety. They didn't want an LNG plant in the middle of a residential area, an LNG pipeline. LNG, if it explodes, is very dangerous, and they just didn't want it there. But they also had other reasons too. They wanted to have this area where they're going to put the LNG tank be a residential area, and a mixed use urban high transit blah 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 area. And they didn't think that tank was the right thing for that location. So, but the company came in and said, well, you can't consider safety at any degree. And if you consider safety at any degree, it taints the decision, and therefore it's preempted in your decision on this, where this tank can be located, is void. The court looked at that and disagreed with the company, and they said that that Congress did not intend to occupy the field of facility siting, which is distinct from the field of pipeline safety, and that even assuming safety concerns played some part in the county decision, such consideration was incidental and did not convert the county decision into a safety regulation. So, a decision on where to put something is not the same thing as imposing a building code on that. Essentially is another way of thinking of this decision. The next case is the South Portland case, it's South Portland, Maine. And there's a proposal to reverse the flow of a pipeline to bring oil out of Canada down to the South Portland, Maine, which is a harbor, and to load it on oil tankers and to ship it overseas. Well, the city passed an ordinance to prohibit the construction of a crude oil pipeline facility that would allow it to pump oil in the opposite direction, meaning it was originally bringing oil from Maine going up to Canada. Now it's going to take from Canada down to Maine. They had to change some of the equipment to do that. And the city was very concerned. There's lots of evidence. The city was very concerned about oil spills and about the safety of having this stuff going into the city. And the company argued that this consideration of safety was preempted by the Public Safety Act. And the court, again, rejected the pipeline company's arguments completely and said, a prohibition on a facility is not a safety standard, it's a prohibition. They looked at the definitions in the dictionary to figure that one out. The prohibition did not establish any safety requirements. In other words, saying no to something doesn't actually impose any requirements like pressure limitations or steel thickness or anything like that. It's just saying no. An outright ban did not frustrate the purpose of the PSA. The local governments, if local governments, if they don't think a pipeline should be built at all, have the right to say no. And if they just simply say no to it, then the PSA never comes into effect because the pipeline never constructed. And the prohibition on routing in the PSA meant that the PSA did not restrict the city's discretion to construct the facility. Again, the court recognized that the Pipeline Safety Act, prohibition on PHMSA routing a pipeline, it means that this area of law was up to the city's discretion whether this facility should be constructed or not for whatever reason the facility chose. And then the Bad River Band decision, and this is out of 2022 out of in northern Wisconsin. And the Bad River Band had the right of way through for the Li-Fi pipeline, went through their reservation, and they said they didn't want to renew their easement, their lease agreement, the right of way agreement with Enbridge, because they were concerned about the safety of the pipeline because it was getting old. They just wanted it off their reservation. And Enbridge sued in federal court, and they claimed that the decision not to route a pipeline through the tribe's reservation due to safety concerns was a safety standard. Again, the same thing. The tribe was saying, not in this location. We don't want your pipeline on our reservation in this location. We want you to do a different route. And we don't want it here because we're concerned about oil spills. And the court held that while the band's refusal to consent to easements may be based in part on safety concerns, it is not based on the imposition of safety standards. Again, just because in a routing decision, and government has safety concerns doesn't mean that it's imposing a building code, on a pipeline. They're two different processes. One is the zoning type process, the where it goes process. The other is the how is it built process. And the feds don't regulate the where it's built question. They just don't. So considering safety concerns is not the same thing. Should also say that Minnesota Supreme Court decided or had a case on this also. It's the only state court that's looked at this exact issue. I don't have a slide for it, but the Minnesota Supreme Court looked at the same issue and said, nope, the state can consider safety and routing, and we're going to allow that. And it's the PUC in Minnesota expressly chose between two significant route options based on the risk of oil spills to different locations, and they chose one of these route options based expressly on safety standards. And we litigated that just so we get it in the courts, and the Supreme Court of Minnesota said, nope, consideration of safety is not the same thing as imposing a safety standard. So all the court cases that have looked at that issue, all of them, without exception, are on our side and against the industry. So here's some policy factors when you think about pipeline routing. Since PHMSA can't route a pipeline under the PSA, it also cannot impose safety standards related to routing. It has no route permitting process. PHMSA's regulations just simply don't have a permitting process. There's no standards there for like a void hospital. So this is the separate one I'll talk about in a second. There's just simply, no safety standards or no permitting process in which PHMSA could look at a route and say, and pick a route, because that would violate the statute that says PHMSA can't pick routes. The PSA safety standards apply to any route chosen by a state county, regardless of reasons it was chosen. As I said, a state or county can choose a route, and it doesn't really matter why it's chosen. The building code still applies to it regardless of why it's chosen. It doesn't make any difference what the policy factors are to the full application of the Pipeline Safety Act. And then if PHMSA cannot select a route based on safety, which it can't, because it can't pick any routes, and if a state or county can't either, so the industry is saying that nobody is saying that state and county can't consider safety either, then the answer that what the industry is really saying is that no agency at any level of government could ever consider safety in a routing decision. So that means that it would be left up, what the industry is really arguing is that it and only it can decide whether a route is safe or not. And there's no evidence that Congress intended that result from the Pipeline Safety Act. This is really an extreme position from the industry, because it means that, if they picked a route that took a carbon dioxide pipeline right by a nursing home or a hospital or a school, and if, the state and local governments can't say that's a bad route, if PHMSA can't say it's a bad route either, then the industry could just ram that route down the local people's throats, and we'd all be at the mercy of the pipeline industry. Like I said, there's no evidence that Congress intended to have no agency consider whether safety and routing. They just said PHMSA can't pick a route. But they didn't say, and state and counties can't consider safety. And it just makes no sense from a societal level to prohibit all government agencies from being able to consider safety when a pipeline is being routed. There's just no evidence in statutes or law that Congress wanted nobody to have that authority, and that's what the industry is arguing. So you hear this argument about 49 CFR 195-210 entitled pipeline location. This is the so-called setback law or regulation by PHMSA. First off, again, this has to be read in light of the prohibition on routing or locating or routing pipelines in the Pipeline Safety Act itself. Remember, this is a regulation. It is subservient to the Pipeline Safety Act, the statute. So let's look at subpart A. Pipeline right-of-way must be selected to avoid, as far as practicable, areas containing private dwellings, industrial buildings, and places of public assembly. Sounds like PHMSA's regulating route. Well, doesn't matter if PHMSA is trying to do that, it can't. Where this language came out, and I tracked this way back, even into the 1950s, it's really this language started coming up in the mid-60s. This is very old language that was put in place before the understanding of state and federal regulations were in place and developed. And it's been around for a very long time. Well, in 1994, let's get to the next thing. In 1994, Congress passed 6014E that says this chapter does not authorize the Secretary of Transportation to prescribe location of pipeline facility. So what you have here is a very old statute that's been kept on the books, and then Congress passed, a clarifying provision in the Pipeline Safety Act that says, but the federal government can't route pipelines under the Pipeline Safety Act. So, and there's a basic rule of law that a newer statutes always trump regulations, and newer statutes trump older statutes or older regulations. So when Congress made clear that the federal government isn't going to route pipelines, then this old regulation was essentially mooted or voided by the act of Congress. And it's just that PHMSA has been too freaking lazy to get rid of it. And I think maybe that's because PHMSA is often on the side of the industry, and this industry likes to talk about this provision as regulating pipeline route. But again, PHMSA has no permitting process. There's no way, if you look at this language, pipeline right of way must be selected to avoid as far as practical areas contained. There's no way PHMSA could enforce that. It has no permitting process. It has no standards for other than this. It has no ability to tell a company you didn't do this and therefore you have to move your pipeline. It's prohibited by statute from enforcing this provision. So now let's look at the section B. No pipeline may be located within 50 feet of any private dwelling or industrial building or place of assembly in which persons were congregated assemble, unless it is provided with at least 12 inches of cover in addition to that prescribed by section, the basic pipeline standards. So what this says is that a company can build a pipeline down here within 50 feet of a building only if they add another foot of dirt on top of it. Or they can build it further away than 50 feet. So a setback is something that says you cannot build a facility within a certain distance of another building. Well, this allows you to build within 50 feet. You just have to put more dirt on top of it. So this is not a setback. It is a depth of cover regulation. It says if you're going to get too close to a building, then we're going to have another foot on top of dirt on top of it because it's going to increase safety by having more dirt over the top of it. If this just said you can't build it within 50 feet, period, then it would be a setback. But PHMSA can't do setbacks because setbacks relate to location. And again, the US Code 60104E expressly prohibits PHMSA from determining the location or route. PHMSA can't issue setbacks. It'd be in violation of the statute. They don't exist. So, the industry talks about this as being a setback, but A, it doesn't prohibit construction within 50 feet. And B, it can't be interpreted that way because that would violate federal law. So, okay, so that's the location and route issues. Let's move on to emergency response issues. So, does the PSA preempt state and local emergency response? Here's the relevant language, and again, 60102A related to safety standards. The Secretary may prescribe minimum safety standards for pipeline transportation for pipeline facilities. The standards may apply to owners, operators, pipelines again, and may apply to emergency plans and procedures of pipeline facilities. Therefore, it's very clear that counties cannot regulate the emergency response plans and procedures of pipeline owners and operators. So you can't tell, and this is for carbon dioxide pipelines, a different rule for oil pipelines, but the counties can't tell an owner or an operator of a pipeline how to respond to an emergency, how to plan for an emergency, or tell them to do anything related to emergencies. So that's just a hard stop. Counties can't tell the pipeline companies how to deal with their emergencies. That's strictly regulated by federal law. But local agencies, response agencies, are not owners or operators of pipeline facilities. Therefore, PHMSA has no power to regulate their emergency response plans or activities. These are the government plans and activities. So the PSA Public Safety Act does not federalize emergency response. If there's a pipeline rupture, your local cops don't have to wait around for the pipeline company to show up to rescue you, or the fire department. They can jump into action right away, and they can do it however they want at their discretion. This is not, some kind of European country where, all the cops and all the firefighters and all the emergency medical people are all federal employees, or beholden to the federal government. The Pipeline Safety Act respects the fact that local governments control their own emergency response. But PHMSA's regulations recognize that this is how emergency response works in the United States, that there's multiple agencies and companies and levels of government that are dealing with emergency response. And so the federal regulations require that pipeline companies coordinate. Remember, it's not direct, but coordinate with local response agencies. And these are two of the examples. There's a bunch of them in the pipeline regulations that require that pipeline operators coordinate with local response agencies. So essentially, what's supposed to happen is the pipeline company has its emergency response plan, and the local agencies have theirs. A local agency should not expect the pipeline company to do a response plan for them. Pipeline company doesn't know about law enforcement. It's not a law enforcement agency. It doesn't know about firefighting. It doesn't know about, emergency response. It's not a hospital. So the pipeline company knows how to respond technically to pipeline ruptures, including things like shutting valves and isolating the area and starting to investigate why it's pipeline ruptured. Those more technical things, but the pipeline company doesn't know how to rescue people, and it's not going to have the equipment to rescue people, and it's not going to want to do that, because if it tried to and it screwed it up, it would become liable. So the pipeline company employees are going to come there and they're going to do their very limited job related to that technical response to the pipeline, and it's going to be up to the firefighters, the police, and their emergency medical people to do their jobs the way they see fit. So it's critically important that local emergency response agencies, including hospitals, get a sense or have emergency plans and procedures in place, because they're going to be on the front lines of these CO2 ruptures. Probably most of the employees of the CO2 pipelines, including their contractors, are going to be a long way away from any rupture. By the time they show up, it could be 2 or 3 hours, especially in the winter and a blizzard. And, the people that are going to be on the front line there are the first responders, the local folks. So they have to have their own act together, because the pipeline company isn't going to come right into the rescue and rescue everybody. Pipeline company is going to come in and shut some valves, and they're going to wait for the pipeline to vent, and then to come investigate. Pipeline company is not going to drive in with a lot of vehicles and start hauling bodies out, before they die. It's not their role. It's up to the local agencies to rescue people, and they have to be prepared in their own way, to their own discretion. But they can also ask the pipeline companies for information that will enable them to do their jobs. Because simply asking a pipeline company for information, safety information, doesn't tell the pipeline company how to respond. It doesn't tell the pipeline company what should be in the pipeline company's plan. It just says, tell us how far the CO2 is going to go, or tell us what's in the mix on the material safety data sheet. Tell us whatever you think you need to know about the actual risks of these pipeline, that the firefighters and police need to know. What's the danger zone? All those kinds of questions aren't telling the pipeline company how to respond. It's just saying, tell us information. And the pipeline company is fully capable of doing their own plans in their own way and responding in their own way. Asking information doesn't restrict any of their actions. It's just simply information. So this is just a quick summary here. So there's a bunch of things that counties can do. They can route the hazardous pipelines. They can do emergency response. The company has an emergency response plan, but counties have their own emergency response plans. They can regulate the mitigation aesthetics for CO2 pipelines. They didn't get into that. It's not really controversial. And then there's post-abandonment mitigation. Let me move into that now. So does the PSA regulate abandoned pipelines? The Pipeline Safety Act expressly regulates only pipelines that are used or intended to be used in transporting hazardous liquid. So why is that? Well, if a pipeline isn't used or intended to be used for transporting hazardous liquid, it's no risk of any rupture. I mean, if it's not, doesn't have anything in it, then there's nothing going to spill out of it. If it's not being operated, if it's empty and just not being operated, then it's no longer poses a safety risk. And so therefore, there's no reason to regulate it under the Pipeline Safety Act. So the Pipeline Safety Act applies to operating pipelines or pipelines that are intended to be operated at some point in the future, those under construction, or if they've been mothballed for some reason. So this begs the question then, what happens when a pipeline is abandoned? When does federal jurisdiction end? It ends when it's no longer used or intended to be used to transport hazardous liquid, but how is that proved? And the federal regulations define the physical administrative steps that a pipeline operator must take to formally show it is no longer using or has intention to use a pipeline to transport hazardous liquids. So what the pipeline operator has to do is to seal the pipe, is is separate the pipeline from other operating pipelines, purge it of all combustible materials, and then seal the ends. And at that point, that's proof to the federal government that it's no longer being used or intended to be used. And then for certain pipelines, the operator has to also send a PHMSA notice saying we're no longer going to use this pipeline. At that point, these pipelines are no longer in federal jurisdiction because they're just empty steel, tubes of steel in the ground. They're no longer being used to transport hazardous liquids. So therefore, the Pipeline Safety Act's pressure standards, its steel standards, its maintenance standards, all those things no longer apply because it's no longer a pipeline within the meaning of federal law. It's just rusting steel in the ground. So once a pipeline company takes these steps to prove that its pipeline is now abandoned, the federal government no longer has any jurisdiction over that steel. So when the companies all come in and say, well, but the Pipeline Safety Act, the regulations expressly regulate pipeline abandonment. What that means is they regulate that last moment in time. They determine that last moment in time when federal jurisdiction applies, because they need to determine when the federal jurisdiction ends. But once that abandonment is proven, then the pipeline becomes no longer being abandoned, but it is abandoned, and there's no federal jurisdiction. So, again, this shouldn't be controversial. I mean, Minnesota imposed abandonment requirements on both old Line 3 and new Line 3, and Enbridge did not threaten litigation. I think they knew they would just lose if they tried to. And this is very expensive. Landowners should be clear. I mean, if you want to remove these pipelines, old Line 3 in Minnesota, 34-inch pipeline, was $1,000 a foot to remove it. So if you want to get this pipeline removed in the future, 24-inch pipeline or 20-inch pipeline in South Dakota is going to be less expensive, but it's still going to be hundreds and hundreds of dollars per foot to remove it. And the pipeline companies don't want you to think that you have any right to get rid of that old pipe once it's abandoned. The other thing about these CO2 pipelines is, remember, the federal tax credits only last for 12 years once the pipeline starts operation. So what happens at the end of 12 years? Are you stuck with this old pipeline on your property in perpetuity and you can't get the company to do anything about it? And these companies, this is the Enbridge estimated is $1 billion liability for old Line 3 if it was all removed. They're just terrified of having people think that they can do something about this. Now, Iowa Code 479B32 also regulates abandoned pipelines, and it's never been challenged in court. And it gives landowners the right to decide what happens with their pipelines once the pipeline is abandoned. Once that abandonment process is finished, federal law no longer applies, and it just becomes steel in the ground. And it's just, what do you do with the scrap metal? That's all it is. So this is also, I put in here just a summary for natural gas pipelines. You can see a lot of stuff in the red is preempted. For oil pipelines, a lot of it's not preempted for various reasons. And for CO2 pipelines, a lot of it's not preempted either. So, again, you can't regulate safety standards. You can, for oil and gas pipeline or CO2 pipelines, regulate location and setbacks. And you can't regulate emergency response plans for CO2 and natural gas pipelines, but you can for oil pipelines because of the Oil Pollution Act, which is a different law I didn't talk about. The county emergency response, its own plans, they're not preempted by any of these laws. And construction, mitigation, and operation is preempted for natural gas pipelines, but not for oil pipelines or CO2 pipelines. I'm not going to talk about depth cover today. It's another issue. And then abandonment for natural gas pipelines, FERC deals with abandonment issues, but it doesn't regulate it for oil pipelines or CO2 pipelines. So anyway, that's that. And again, there are some very specific rules here and some very specific issues that have to be considered. So it is a bit of a threading a needle when you do your ordinances. But if you write them carefully and you're aware of how the law works and you don't overstep your bounds, then the counties can regulate these pipelines in South Dakota. And so, but again, I encourage you all to seek legal advice when you're drafting your pipelines, because this is not, I think it's clear that pipeline companies can, or that counties can regulate pipelines, but you have to do it very carefully and well. And if you do that, then you're very likely to get sued because the companies have more money than, more federal dollars, more of our tax dollars than they have any right to have. So they're probably going to sue, but that doesn't mean they're going to win. Again, they sued in South Portland, they sued in Prince George's County, and they sued in Nevada River Band. They lost all their suits. So just because they're going to sue doesn't mean they're going to win. But thank you for your attention. I know it's been a lot, and I hope this has been useful. The ordinances that I helped to draft have provisions in them related to all these things, and I've drafted the ordinances specifically to avoid preemption problems. Now, of course, the companies are going to say it is a problem, but again, the law is very clear in these areas, and and I think that the companies just literally make up a lot of baloney about what counties can't do because they just want you to surrender before you even start fighting. So hope that's useful, and I'm happy to answer any questions.
Yes, thank you so much, Paul. That was a whole semester's worth of knowledge, very articulately put in a very good format. So thank you. I'm going to start off by throwing a comment out there for you to maybe offer a comment on as well, and invite people, if you have questions, go ahead, put them in the Q&A, click that button on the bottom of your screen, and we will stay on and answer questions as they come in. If you've got to jump, again, a recording of this will be made available. So don't worry, you'll be able to come back and check out the Q&A if you have to jump off the call. But again, put your questions in the Q&A. We'll stick around and answer all of them.
Yeah, and I'll just add also, this presentation is very simple. And I know it seems complicated for you, but from a lawyer's point of view, I have memoranda that I've drafted on all these issues in detail. I've spent days researching this. I've watched it over the years. I've read all these cases and more. I've read every case, on all these issues that are federal law, all the preemption, PSA preemption cases. So if you have specific questions, I can answer them. If you need more detailed arguments, I can provide them. This is not me making this up without really thinking about it. I'm providing you a very crib note version of this, that I've written plenty of briefs, plenty of memos, and lots of arguments and lots of emails to people about how all this stuff works. So if you have any questions, my email is paul@boldalliance.org, and I'm happy to provide more detailed responses if particular issues come up.
And I'll also volunteer. Paul has made himself available to county commissioners, to state's attorneys at the county level. Definitely is a resource. If you are one of those, you can reach out to Paul. And if you are a landowner trying to get your local officials better informed and more able to take action on this, certainly recommend that to them that they can reach out to Paul as well. We've got a few questions coming in. I'm going to keep inviting you to drop them. Paul, I'm going to name one thing for you that your presentation brought up for me. I was in a meeting just this afternoon with a county commissioner in South Dakota, and they told me explicitly that the county is considering ordinances. They told me explicitly that the representatives of one of the CO2 pipeline companies told them, just treat us exactly like a natural gas pipeline. And especially when you had your chart up there, which showed this extreme difference between what's preempted for a natural gas versus a CO2, that chart really just threw my head back. Can you comment on that? Because I think that's a line that's being fed to commissioners all over the state. Just treat us like a natural gas pipeline.
Sure. Natural gas pipelines are regulated entirely differently from either hazardous liquid mean oil pipelines or carbon dioxide pipelines. Natural gas pipelines are regulated under the Natural Gas Act. Under the Natural Gas Act, the Federal Energy Regulatory Commission, a different agency from PHMSA, has the authority to decide the route of the pipelines and all the mitigation standards for those pipelines. Between the PSA preemption of safety standards and the Natural Gas Act preemption of routing and mitigation standards, essentially states have very little control over interstate natural gas pipelines. But the Natural Gas Act does not apply, and this has been very clear in the law, decided in law. The Natural Gas Act does not apply to carbon dioxide pipelines because, shockingly, carbon dioxide is not methane. It's not natural gas. So, no, saying that they have to be treated like natural gas pipelines is entirely misleading and simply a misstatement of law, because CO2 is not CH4 or methane. They're different substances. That's all there is to it. So yeah, that's just absolute baloney. And if what they're trying to say is treat us like that, because then we don't get regulated by you at all. And that's what we want, not because we're right, just because we don't want to be regulated by you. So we're going to make some, we're just going to ask you to do that. But it's not, there's no legal foundation for that argument.
Yeah. It's not because they can't afford good lawyers who understand. It's because they understand very well the differences. So the first question that's coming up, Charlie asks, is there any legitimacy to the companies saying you can't enact rules halfway into the game? We heard that a lot at the legislature. We've also been hearing it at the county level. Don't change the rules halfway in the game. Don't change the rules halfway in the game. What would you respond to that?
Well, one of the things that counties can do is pass emergency regulations or emergency ordinances. And this is the so-called moratorium, the right for counties to pass moratoria to stop developments of certain sorts, certain types. And it's in chapter 11.2, and I forget the exact, but we can get that to you, the exact provision. But South Dakota's statutes are very clear that that a county can put a moratorium on development projects. Now, there's nothing in that says that they can't do that once a pipeline application is filed at the PUC. It just says they can put a moratorium on. And frankly, the whole point of an emergency moratoria is that some new, development type is coming in, and the counties aren't really ready to deal with it yet. And it says you can take up to a year initially to study this issue and to figure out your ordinance, and it can be extended by another full year. If there was a rule that you couldn't regulate people halfway through, then the only time that counties deal with this is when they learn about this new development types of development. So essentially what they're saying is, well, you could never do a moratorium because by the time you hear of it, it's too late. You're already halfway through. No, the statute doesn't say anything about not applying to projects if they're trying to move ahead. It just says you can pass an emergency one and get an emergency ordinance and stop the development. And I haven't read anything else in state law that says that just because it's been filed at the Public Utility Commission and therefore counties can't do their own regulations. At the same time, it also is clear that if you want to get these ordinances considered by the Public Utility Commission in terms of their reasonableness and have them be considered in that process, then you need to get the ordinances done so they can be provided to the Public Utility Commission. Now, North Dakota has a law that provides a deadline for when counties have to take action, but South Dakota has no deadline in their statute. So it's another indication. So North Dakota says you have to have it to the Public Service Commission in North Dakota 10 days before their hearing. I believe it's 10 days before their hearing. South Dakota has no deadlines in the statute.
Hey,
So,
Chase,
Yes.
that's -2-10.
11-2-10, yeah. So you should read that.
Perfect. The next question is from Mary. She asks, if a pipeline ruptures, what liability does the landowner have?
Well, that is a complicated question or uncertain question to answer because it depends what the landowner did. Now, Brian Jordy, one of the things he talks about in his presentations is one of his clients was bulldozing some trees, I believe, and the pipeline, there's a gasoline pipeline or diesel pipeline or maybe both, And the bulldozer broke the pipeline. Now, there were no signs around alerting them, and they didn't even realize the pipeline was there anymore. But the pipeline company sued them for the loss of the oil and gas. So it depends. I mean, if the pipeline company can dream up any conceivable argument that it's your fault, then you could be sued by the pipeline company for the damages caused by a rupture. And it depends on whether they can find something that you might have done wrong. Now, if you didn't do anything wrong at all and they can't prove it, then then you might not have any liability. Now, one of the things that we put into the Keystone XL permitting, and hopefully go into any other carbon pipeline permit conditions, is a condition that landowners who are farming during normal farming operations have no liability in the event that the pipeline is damaged by them. So, regulators can, and counties might be able to do this too, but I'm not sure about that. But the state regulators, the PUC, can limit landowner liability for innocent operations, for innocent actions.
And I would add, I think a lot of that also would come down to what easement you sign. If you've signed the first easement that the company sent out, they've left lots of wiggle room to put liability onto you. And those same lawyers who know very well the difference between natural gas and CO2 are also drawing up their easements to give as much wiggle room for them to come after you later. So definitely, if you're a landowner being crossed, get your easement checked by a lawyer. And I'd encourage you to check out the South Dakota Easement Team, which is a group of hundreds of South Dakotans being impacted by these CO2 pipelines, who have hired that attorney, Brian Jordy, to do that type of work and represent them through the process. We've got another question here. And then there's also one in the chat that I'll get to after this. So Aaron has asked, would a lawsuit cost the taxpayers of the county if a pipeline company sues the county?
It's possible. It depends on the county's insurance. I know that sometimes, like I believe Shelby County, Iowa, a lot of their litigation costs are being paid for, or not Shelby, maybe Shelby, I'm not entirely sure of that, but Story County also is being paid for by their insurance company. So, you have a lot of counties have insurance against being sued. And so therefore, the defense of that ordinance may be paid for by insurance, but you'd have to check with your county administrators and county attorney about that, because I think it depends on the terms of the insurance, whether there is insurance, and then if there is, what the terms of it are. And even then, it may not cover all the costs. But I think this is where, there are many costs of doing business, to protecting citizens. And even though there may be a cost to it, the county can just decide that protecting citizen rights is worth the money and worth the financial, cost of the litigation. And again, I think, I don't know what the state's attorneys are saying, but let's say a county does get sued. Well, the county can look at the suit, they can look at the legal arguments that the company's made, and if they think that the legal arguments the company's making have merit and that the county's likely to lose, then they can just simply rescind their ordinance and the litigation will go away. It's not like just because you get sued that you're definitely going to pay vast amounts of money in all circumstances. It depends on whether you think that how long you're going to fight this, whether it's worth fighting. And then it can cost some money, but it may also be possible, for example, if counties have similar ordinances, to all bond together and to share the costs of legal defense of a similar ordinance. There are ways of limiting the cost to counties, and there are ways of avoiding litigation altogether. One of the things, for example, that is the Lincoln County ordinance is regarding setbacks, is that there's what's called a variance provision. The variance provision says, if you think our setbacks are unreasonable, then aren't going to work for you, or going to prevent any pipeline from being built, or whatever reason, then tell us what the danger zone is around them. Tell us any safety information that is relevant, but also tell us what you think, how we're breaking the law. You know, if you want to, if you think that we're doing something wrong that's illegal, then tell us that they're all your arguments. And then the county can consider them. And I think the legal arguments have merit at the county level. And before it gets to court, they can say, okay, well, we'll change our variance or we'll change our setback so that it's reasonable. And you know, and then if they give they can negotiate a reasonable setback with the pipeline company, and the pipeline company won't sue them anyway. So, you know, and generally speaking, there's another rule in litigation that that you can't sue a government agency until you've exhausted all your administrative remedies. So a pipeline company couldn't come in and say that the setbacks are unreasonable without trying to get a variance. They'd have to try to get a variance before they could sue. You know, so by having that provision in there, essentially what it means is that you can get a preview of what their litigation is before you go to court, see if you think it's reasonable, and then you can change your setbacks to you know, to avoid litigation. So there's a variety of ways of handling this to not, you know, it's just because you might get sued doesn't mean you will. And if you do, it doesn't mean you have to stay in it. And it doesn't, even if you stay in it, it doesn't mean you're going to lose. So.
Yeah, thank you. And I think one of the things I love about that piece in the proposed Lincoln County ordinance that's being pushed by landowners there is where it lays the burden of proof. I think in this fight, county commissioners have been hearing from landowners, hey, you've got to do something. And we're researching this. We're talking to attorneys. You can do something. And then their commissioners are hearing from the company who, in bad faith, in my opinion, has been making misleading statements about like the natural gas, that idea, but also in telling the counties, if you do anything, there will be lawsuits, right? And so putting that piece in there shifts the burden of proof onto the companies instead of county commissioners or county government being made scared about the threat of lawsuit, telling the landowners to prove why we need setbacks or why the numbers are right. It's the companies proposing the project. They should be the ones carrying the burden of proof to show what those rupture models risks are. And we've got a question about that coming up, which we'll get more into. I'm going to jump over to the chat though. Walter asked a question. What is the setback from a grade school?
In the ordinance, I forget. I think that's 2 miles in the ordinance. Tony might remember. Yeah, I think that's considered a high consequence area under the ordinance, and so that would be, I believe, a 2-mile setback.
He's correct.
And to clarify, that's the proposed ordinance that landowners have brought forward. If that ordinance, if no ordinance is passed by a county, what would the setback be at that point?
There wouldn't be any setback.
In Lincoln County, it's a setback of 50 feet.
Oh, 50, yeah, I mean, a building setback, but there wouldn't be a particular pipeline setback.
Yes.
Wow. In the Q&A, we've got this question here. Pipeline companies won't release their plume modeling or risk assessment, stating that it would be detrimental for a terrorist attack. How can our counties get these studies released in order to determine setbacks? And a touch of context on this, in a sworn in testimony that's on the PUC docket for one of the companies, a representative was asked about rupture modeling and said, we won't release that information because then somebody could use it to take a terrorist attack. So that's the context for that. And then they didn't answer the question.
I'm going to take a quick break. I'll be right back, and then I'll answer the question.
Perfect, perfect. We've had you on the spot. Well, as Paul steps away for a moment, I will just say that it certainly did not make me feel more comfortable for the company to compare their infrastructure project, which they're claiming we have no right to say no to and no right to route, to compare that to a landmine or something else that could be used as a terrorist attack. So, excellent question. If anybody else has questions out there, you could take this minute and go ahead and drop them in the Q&A or in the chat. Yes, I see Mark posted in the chat. Yesterday, just last night, a county in North Dakota, Burley County, which is where Bismarck is located, they just passed a new ordinance, which was very strong, and I think shows what counties can do if they are willing to. It passed unanimously last night, that the first provision was that they requested no permit be issued until the new PHMSA regulations are issued. And then secondly, they put in their ordinance a request that the PSC, or the Public Service Commission, deny the proposed route and corridor throughout the county. So that, I think, showed a county that was willing to take pretty strong action and put their opinion into the state regulating agency.
So getting back to the question about the modeling plume release, it's very frustrating because, for example, for natural gas pipelines, there's a federal regulation that expressly determines what's called the potential impact radius. In other words, the danger zone around a natural gas pipeline. It's just a formula that anybody can do based on pipeline diameter and pressure. So it's not secret. You can find out for natural gas pipelines what the danger zone is around one of them. It's in public regulations. And yet for CO2 pipelines, the companies are saying that, oh no, any knowledge at all about what the danger zone for these pipelines is secret. Now, the Minnesota Public Utility Commission, the Enbridge argued that it's spill modeling for oil pipelines. In other words, the place that would be damaged by oil pipelines was all confidential. And the Public Utility Commission rejected that argument and said, look, this is just an estimate of what the danger zone would, or the spill zone would be around this pipeline. It's not going to help anybody, rupture the pipeline. I mean, everybody knows where they are. They got signs saying where the pipeline is. It doesn't say what the worst place, the place that would be the most damaging to do a rupture. It just says here's the range of areas that could be, the distances that could be affected by a pipeline or an oil pipeline rupture. And the same is true for CO2 pipelines. Knowing what the danger zone isn't going to help terrorists, but it will help citizens, first responders, and other people who need to know whether they're at risk. And also the plume modeling that the companies do can be recreated by anybody with the money and the resources to hire what's called a computational fluid dynamic modeler. This is not secret software. This is not secret data. The pressure of the pipeline, size, the diameter of the pipeline, the length of the pipeline between valves, all those things are all publicly known. And those are what you need to know what the modeling is, what the danger zone would be. The models are out there. There's scientific papers on them. It's all public. So when they say that this plume modeling is secret, well, the data underlying it isn't secret. The models that they use to generate these results aren't secret. So how can the output of the model be secret? And anyway, if you can afford to find somebody and hire somebody to do this work, they can do it for you. And they can do a good estimate of what the danger zone is as well. So how is it secret? Well, just because the pipeline companies like to say it's a secret for national security reasons, but they don't. It's not because it's really about national security. It's about corporate security and about keeping people from being worried about this. But it's just another way that the rich and powerful can use concerns about safety to protect themselves rather than actually protect citizens. And let's face it, if citizens know about the risks they face, if they had CO2 detectors in their houses, if they had evacuation plans, if there was an alert system that would alert them in case, like the Source Valley Pipeline, CO2 pipeline North Dakota does, a sort of an Amber Alert type thing, a text and cell phone alert to if there's a case of a rupture. If you do all those kinds of things, citizens can be trusted to, some of them, to take care of themselves. Some of them may not be able to, invalids or shut-ins or, elderly people or people with mobility limitations. They're going to need help. But, citizens who can help themselves should be empowered to help themselves and not just be seen as weak little victims, which is what the companies, it's like, well, don't worry about it because if something happens, we'll come and rescue you. No, there won't. It won't be there in time. You need to help yourself get out of the situation. And if you can't, then your first responders need to be responsible to help you get out of your bad situation. But the more you know, the safer you can be. And knowing the danger zone on these pipelines is important, so you know how far to get away if it does rupture. And knowing your escape routes will be important, and that can be affected by the danger zone. Like how far do you have to go? You might have to go in a direction, away from it, upwind, basically, so, or maybe downwind. But you just need to know that. Anyway, that's it's frustrating, but hopefully, as time goes on, we'll have public model results out, and we can just show that this industry fear is just all fabricated.
Yeah. Well, I don't know anybody who's staying up at night because they're worried about terrorists, but I know a lot of people who are up at night worried because of these companies. So the last portion of that question, maybe we could touch on one more time. They asked if counties can require or request that plume modeling to be made available. Is there anything that prohibits a county, say in a conditional use permit or a special permitted use, from requiring that information to be made public?
Well, again, the pipeline companies all say this is safety related, therefore counties can't know it. But counties have emergency response, obligations to their citizens. In the case of a pipeline rupture, aren't emergency response obligations safety related? Isn't what public safety departments do, like police and firefighters, related to safety? Doesn't having informed and prepared police and firefighters, emergency medical response folks improve safety for citizens in the event of a pipeline rupture? Local emergency response is definitely related to pipeline safety.
Yeah.
So, just because it's related to pipeline safety, remember the Pipeline Safety Act doesn't regulate all things related to pipeline safety. It regulates safety standards imposed on owners and operators of pipelines. So, yeah, the local agencies can definitely conduct planning. They can conduct their own training. They can buy their own equipment, or they can require the companies to pay for it. But again, having the companies disclose information necessary so that local emergency responders can do their jobs doesn't tell the pipeline company how to do its job. It just says share. And like one of the regulations expressly requires that the pipeline company provide the MSDSs and material safety data sheets, which is about what's in the pipeline, which is material safety data sheet. It's about safety. They have to provide those to local emergency agencies. So anyway, and the other thing is that, again, as I said, pipeline companies aren't cops. They aren't firefighters, and they aren't doctors and nurses and emergency medical paramedics, or they're not that. So they don't know how to plan for any of those emergency response agencies. They know how to go shut off valves and inspect the pipeline after all the damage is done. But these pipeline emergency response folks are not going to be helping the local first responders to any significant degree, if they even appear, within the first 2 or 3 hours, which they may not.
Right. Yes. In every way, downplaying the risks associated with them, so that the rightly warranted concern and action isn't taken. One other question here in the Q&A is from Dana. If land is sold with a pipeline on it, what is the liability?
Well, I think the liability doesn't change based on sales. The liability be the same as I said earlier. If the company can figure out a way of making you liable, they will. And as Brian likes to say, what about, didn't you drive your heavy grain trucks and combines over that pipeline? Didn't it stress it out? Did you do something to cause erosion on your land so the pipeline got exposed? And so when you hit it with your, deep river, your plow, that was your fault because you did too much erosion. If they can figure out a way to blame it on somebody, and try to get it out of you or their insurance company, they will. I mean, they're into it for profit, and so they'll maximize, their financial benefits at your expense. There was also a question about the sovereignty of tribes. Now, the Pipeline Safety Act is an act of Congress, applies to reservations and tribes as well. So tribes cannot, are not exempt from the Pipeline Safety Act's, preemption provision. So tribes cannot direct a pipeline company how thick its pipe should be, what the pressure would be, how it operates the pipeline, how it designs its pipelines. The federal statute supersedes the tribal law. It's just like federal law can trump the state law, federal law can trump tribal law too. I think people disagree. Some people don't understand that, but that's the case. The tribes just can't come in and impose their own pipeline safety standards.
Mm-hmm. Right. However, I think there's a lot
of their routes are not through their pipeline, and they can do things related to abandonment. They can do everything the states can do, but they just can't tell a pipeline company how to operate its pipelines.
Right. But there's still plenty of space within the tribe to do regulation. As you've pointed out, counties have a lot of capacity. You take that, bundle it up with state power as well.
And tribes can do as much as states can do.
Right. And a point on that, and thanks to Paula for bringing that point up in the chat. I think that clearly in previous pipeline fights or issues in the past, there was a tremendous working hand in hand between native and non-native folks and landowners who stood together, utilized both tribal law, sovereignty, and also pushing local, county, and state action with great success, particularly on the Keystone XL fight. And so when you start getting into issues of affecting the land, all those who have stewarded, are currently stewarding the land, really band together in a way that is powerful to see. So,
and I would reiterate, the Bad River Band case up in Wisconsin. Bad River Band wanted Line 5 off the reservation because they were worried about the safety risk. And Enbridge said the tribe doesn't have a right to consider safety in its routing decision, in a right-of-way decision. And the courts were on the tribe's side. They just were. But the industry again is arguing that even tribes don't have the right to throw a pipeline off because they're concerned about safety. Unfortunately, the federal court came out, with a proper answer, and it was consistent with the South Portland and the Washington Gaslight cases. So, again, tribes have some very unique powers. They're one of the few entities that can just simply say to a pipeline, you can't cross our land, period. And we don't have to explain why. We just don't want you on it. So tribes do have some very specific and real powers. They just have to understand what the limits are.
And I think after the great success that was seen in some of these past pipeline fights with the tribes leading, these CO2 pipeline projects have clearly avoided reservations in South Dakota, and through most of their route have done a intentions job of avoiding that particular issue for them. I don't see any more questions in the Q&A or in the chat. So I'll remind folks again, a recording of this will be made available and sent out. I'll send it to the email list that I have. It will also be posted on Dakota Rural Action and Bold Alliance's social media pages. I'll give many, many thanks to Bold, Nebraska, to Tony Ventura, to Paul Blackburn for being on. And Paul, if you have any closing comments or anything you'd like to say.
I would just say, that local governments should defend their citizens. They should defend their rights, and they shouldn't be made to be afraid just because they're going to get sued. And before deciding whether you're going to bow to the threat of suit, you should really talk to somebody besides your state's attorney. You can get a separate legal opinion, because the state's attorneys may very well have other interests and perspectives, and not all of them are going to understand this law terribly well. Think about how you can educate yourself about what this law is. Another point I'd make is that the state's attorneys are always coming in with the executive sessions, and seeking to talk about these issues in private. Well, the executive session is to talk about the threat of litigation, but that's not necessarily the same thing as interpreting what the law means. So, I think that the county should request written opinions by their state's attorneys about what the law means, apart from providing advice on the threat of litigation, just to say what the law means. We know that, for example, the attorney generals of every state issue what are called attorney general's opinions, where the attorney general just says what the law means, and those are all public. And here, it would be great if the attorneys, the South Dakota Attorney General or the state's attorneys would just simply issue a memoranda, or an opinion saying what counties can and can't do in their opinion under the law. Then at least we'd all have it in public. Then it could be responded to by attorneys, your own attorneys, or by me or other folks, or the pipeline industry. But at least we'd have it all out in the open. It's really unfortunate that the interpretation of these laws is all being kept secret, because we don't know what arguments are made to the county elected officials in these executive sessions. So for me to come in and argue against the state's attorney is very difficult, because I don't even know what was argued. It's like, let's all just pretend we can remember, or we can read minds here and understand what arguments are being made. Anyway, it's just something that the county government should do, is think hard about how they can protect their citizens, think hard about how they can get an independent sense of what these laws mean, and be open with their citizens about it. The other thing that the county elected officials should understand is that my understanding is the executive session is there to protect attorney-client privilege. The attorney-client privilege is not owned by the attorney, it's owned by the clients. So if a client chooses to waive their attorney-client privilege, the corporate entity chooses to waive the attorney-client privilege, the county could release some or all of whatever was said by in executive session to the public. That it's there for the county's protection. But if the county believes that some parts of it are public, like what the law means, then the county should really be transparent with its citizens about what the law means, and not hide it, so that we can all understand what's being claimed in terms of the meanings of these laws. But thanks so much for your time tonight. I know it's been a long time and a lot of stuff. Again, I'm trying to ram a lot of stuff here together, but if you have more questions, Paul at boldalliance.org, and I'm happy to answer any questions in more detail and provide more research and background on these issues.
Awesome. Thank you, Paul. Thank you all for being on tonight. There's a lot of experts. There's a lot of resources out here, but ultimately, we need local people to stand up, band together, and push these issues forward locally. So contact your neighbors, get involved, start going to your county commission meetings, find out what's been happening, and don't be afraid to reach out to Paul, to Dakota Rural Action, to other landowners who have been in the media, who have been active, and together we can get something done in our counties. Thanks for being on. Have a good evening.